Good afternoon. We are doing a little Weinhaus again because I keep getting these little comments coming in about Weinhaus. Like, oh my God, you don't know that the watch testimony or the watch video was played in trial. Oh, you don't know these things. Oh, well, yeah, we do. Yeah, we actually do. I have 5 PDFs here. This first PDF is a transcript of February 14th and February 21st of 2013. The pretrial arraignment kind of stuff going on there. Then you have day 1 of his trial. You got day 2 of his trial. You got day 3 of his trial. October 10th, October 9th, October 8th. 3 days of trial. And then you've got sentencing, November 25th. You've got 3 days of trial. You've got sentencing. I've got it all, baby. So let's, since I know that most of the knuckle-dragging retards out there can't read, we'll go ahead and go over a few things. Obviously, I'm not going to read over 5 of these transcripts. They are pretty long, 73 pages, 239 pages, 313 pages, 136 pages, and 63 pages. No, we're not going over them all. But I will have links to these in the description. So if you want to go over them, you're more than welcome to. Yes, I have read them all. I actually made a list of all the just based on their testimony, all the jurors that I would have stricken, and I thought defense counsel did a good job. I think they should have pushed harder on Miss Dubuque, but whatever. What are you going to do? The other big ones, Miss Shear and Miss Pierce, are big ones that I would have gotten rid of, and they got rid of them. So I actually don't have an issue with anything that the attorneys for Weinhaus did. And yes, there were attorneys for Weinhaus. There were, in fact, 2 attorneys. You had Mr. Hugh Eastwood and you had Mr. Christopher Combs. Both of them are attorneys for Mr. Weinhaus. But Mr. Weinhaus started off with a different attorney. He started off with a Wokes, something like that. Muttrux, that's what it was. Mr. Muttrux. They had a difference of opinions. I think their difference of opinion was that Weinhaus was a sovereign citizen. Why do I think he was a sovereign citizen? We'll start there first. The first thing is he filed a bunch of pro se motions. Now, filing pro se motions is not in and of itself a indication of... What happened here? Whoa. It's not in and of itself an indication of someone being a sovereign citizen, but this is a totality of the evidence kind of situation. In the intervening, since February 14th, now remember these 2 hearings are about a week apart, February 14th and February 20th. 21st, February 21st. So they're exactly a week apart. He's filed a number of pro se motions, including a motion to dismiss and a motion for habeas corpus. There's your habeas. Ooh, I filed it habeas. He filed a motion to, D-I-S-M-I-S-S, a motion to dismiss. Yeah, he's got his motion to dismiss. So, and the habeas corpus is like the big one. Sovereign citizens love to file motions for writs of habeas corpuses and corpi. I don't know. Anyway, the deal with that is a habeas corpus. You generally have to exhaust your administrative remedies. And this one was set for trial Of course, the matter is set at trial at the request of the defendant. It was set fairly early. So the point of a habeas corpus is either to get to trial or to get released. I mean, it's... Anyway. So those are 2 things. Another thing that I want to point out is stand under. You'll hear sovereign citizens go on and on about the stand under. Do you understand? I don't stand under that. I'm not accepting your jurisdiction. You're asking me to accept jurisdiction. I don't stand under it. Well, here you got stand under. Do I stand under that charge? I mean, am I guilty of that charge? So no. This is sovereign citizen nonsense. And finally, we are going to look over here, and I'm just cherry picking some of the better examples. But he is a sovereign citizen. Anytime anybody brings up the United States flag doesn't have anything about a gold fringe, doesn't say anything about a gold fringe on it. We're not in a real courtroom. This isn't a U.S. courtroom. We're under Admiralty law because it's got a gold fringe. That's what you normally hear about stuff like this, and it is very sovereign citizen-y. So that is he is a sovereign citizen. The next thing I hear is oftentimes about. Did he, in fact, say you have to kill me or shoot me? This is the defendant speaking. The defendant right here, line 25. Yes, sir, and I understand that, blah, blah, blah. You will also note that as soon as I said, you're going to have to shoot me, they did. He just admitted it. He just admitted it. Now, he was dumb, and he was here without an attorney, but it was his choice to fire his attorney, so I can't help you there. And then his attorney also mentions it here. Let's see. Let's see. Oh, wait, it was over here, I think, yeah. Defendant admitted to it. No, I think it was here. I'm sorry. Oh, wait, yeah, this is it. This is it. This is Mr. Eastwood. This is one of his two attorneys. And he's saying that he said, he didn't say he was going to hurt anyone. He said, you're going to have to shoot me, man. That's not a threat. And Mr. Eastwood is 100% correct. That is not a threat. So it might be indicating some intent, but it's not a threat. So his attorney knows he said it, and Weinhaus admits to saying it. So can we just let that one die? Because it's not going anywhere. Let's see, what else? Oh, yeah, the other thing that I know people are really shooting for is he didn't have his gun out. He didn't have his gun out. Obviously, you can't kill anybody if you don't have your gun out. They're saying that you attempted to kill or cause serious injury to an officer by shooting. It says you attempted to do so. It doesn't say you did it. What it says is you attempted to kill or cause serious physical injury to an officer by shooting it. Attempted to do so by shooting him. What it says is you attempted to kill. Attempted to do so. So it's attempted assault in the first degree. You don't have to have the gun all the way out in order to be convicted of attempted assault. You could be just unbuckling the flap might be enough to get you on attempted assault, provided that the state can prove the intention that you were intending to assault the officer. And Mr. Weinhaus's attorney argued that it was not attempted assault. Wait, hold on a second. We need to go to, I think, was it this page? I get it mixed up. No, it's here because they're talking about the pretrial motions. All right, so is this? So it's got to be here. I'm sorry. There's like 1,000 pages of documents. Is this it? Yeah. So there, one of the things that Mr. East would argue, who did most of the arguments, or who did all of the arguments, he was the attorney who did the arguments, except for voir dire, where Mr. Combs got in there as well. He said basically that the state did not prove that there was the actual assault, and that just drawing a gun, but not just pulling a weapon, but actually, so you have to not just pull a weapon, but actually point it out. That was their argument, and he cites case law generally for a Class A misdemeanor. But the point is that they did argue, they did try to say that the state did not prove attempted assault on a police officer. The judge felt they did. The jury felt they did. So there's really not a whole lot you can do on that. Anyway, I hope that answers questions. I know there are always going to be stupid people out there who believe stupid things. I'm not really going to go over all these. Volume 1 is the voir dire, which is fun. I agree generally with the decisions that the defense attorneys made. I did disagree with them on Miss Dubuque. I think they should have fought harder on Miss Dubuque to get rid of her. Then it goes into Folsom's testimony. Day 2 is more Folsom testimony. Then they go to the expert who tested this stuff for drugs. And just for those of you out there, you might notice in every single video, I don't dwell on the drugs. I don't really care about the drugs. The drugs are meaningless. He's serving his sentences concurrently, which means that all of their times are ticking off. For everything he's sentenced for, all their times are ticking off at exactly the same time. By this point, I think he got sentenced to like 6 months or something like that for the marijuana. That was 7 years ago. At this point, he no longer has any time left on his marijuana charge. It is gone. It is done. He has served that time. I think he got like 10 years or so on the... I don't remember exactly, but I think he got somewhere around 10 years on the opiates charge. And he's served so far like 7 roughly out of those 10 years on that charge. He's also served roughly 7 years on the 30 years that he got for the assault and the 30 years for the weapons charge. So he's got like 23 years left any way you slice it. And as far as my political opinions are concerned, as a matter of law, it was illegal to possess those drugs in the state of Missouri at that time. Whether or not marijuana might be legalized in some form or fashion now, I don't know, don't care. But at this time, it was illegal as a matter of law. My personal political opinion is drugs should not be illegal. I think drugs should be legalized. So, if you want to try to say that I'm an asshole for saying that marijuana should be a crime, I'm not saying that. I'm saying it was a crime, or it may still be a crime. I don't know. And then they go through, I think, Mertens, and then they finish up with Mertens on day 3, and they do the remnant, or they do 3 defendants' witnesses, and Marty Leach. I guess they finish up with Jeff White and Mertens on day 2. Marty Leach starts off day 3. Marty Leach is one of the guys who was fixing the gutter. He had damaged the gutter with his dump truck previously. Him and Steve Everhart came back to fix it. Marty Leach's testimony is that he heard the first shot. He wasn't looking at the time. He was working with the gutter. He turns and looks, and he sees Weinhaus going down and then a couple more shots. He says he doesn't see anything in Weinhaus's hands. He can see the hands. Sounds great. Sounds like it's a witness for Weinhaus. Unfortunately, his memory is somewhat suspect, because the day of the incident, he filled out a police report, and he stated in that police report that he heard 5 or 6 shots, then turned around. Not 1 shot, but 5 or 6 shots and then turn around. So that's issue number 1. And then Mr. Parks asks Mr. Leach, did the fire truck get here before the ambulance? And Mr. Leach has no response, doesn't know. And that calls into question his credibility. Mr. Everhart testified the same thing at, he signed his witness statement, and he testified to the same facts. He heard 5 or 6 shots, then he looked and saw Weinhaus on the ground. So his doesn't really help or hurt anybody. It's just, okay, he heard the shots, turned and looked. Then you've got Heather Clark. Now, Heather Clark is a fun one. She was the clerk at that gas station, and every day Weinhaus would go in there and purchase a soda and a pack of cigarettes from Heather Clark. Now, Heather Clark, Mr. Leach testified, was hysterical, and Heather Clark admits to having been hysterical on the date of the actual incident. And Heather Clark testifies that she was doing an inventory of cigarettes, and she sees the shooting happen out of the window, and she sees the detective, Sergeant Folsom, shoot Weinhaus when Weinhaus is already on the ground. Now, that is not what Mr. Leach testifies to, and that's not what Mr. Everhart testifies to. Nobody testifies to that except for Heather Clark, who admits that she was hysterical. So they make their closing arguments, etc. So that's what these are. Again, these will all be up on the. I'll have links to all these, and this one, Winehaus's little diatribe is not good. So I mean, it's not a very flattering way to end anything. Yeah, but I'm rambling now. So thank you for watching and have a wonderful day.